Well, great. Well, thank you so much, Renee, for joining us, and especially with the technological difficulties that we were faced with. I know this probably doesn't do much for your schedule today, because I know how busy you are, so thank you so much. Well, I thought it might be nice to just allow the audience to hear a bit about your background, since prior to joining the commission, you were an academic at Boston College. And so can you share a little bit about what's been the most surprising changes for you as you've transitioned into the SEC?
Sure. So first of all, just really happy to be here. Apologize about technical difficulties. I'm here at the office at the SEC, skeletal crew. So basically everything's self-service. But I'm really happy to be here. I'm glad that we were able to work this out. I think I should just start off by saying, of course, the traditional disclaimer that the views I express today are my own, not necessarily those of the commission or its staff. So yeah, I transitioned from being a law professor and an associate dean at Boston College Law School to becoming the director of the Division of Corporation Finance at the SEC. It's been really an exciting transition. I would have to say what I've enjoyed the most is just getting to know our staff. I've been so impressed by the depth and breadth of their expertise, and also by their dedication. We have an incredibly heavy workload here, a high volume of filings that we're reviewing, and we're also working on a huge number of rules, but our staff is really dedicated. They always rise to the occasion. They make sure that our work is done at the highest quality and that it's completed in a timely manner. So for me, it's also been really exciting because I get to apply a lot of what I've learned through my own research to the issues that the SEC is working on today. So it's been a great transition. We've had our challenges in addition to IT. We have a ton going on, so we're really busy. It's never a dull moment. I've mentioned the transactional filings, SPACs, de-SPACs, and IPOs. And we're also focusing on a number of special issues, including climate-related disclosures, China-based issuers and their disclosure, and emerging issues such as supply chain issues and other pandemic-related issues. So it's a lot to do, and it's a lot of balls in the air, and it's a lot for us to try to keep track of.
Yeah, I know when we spoke previously, I was unaware of the velocity of rulemaking that the Commission is currently considering. So can you remind me, how many rulemaking announcements have there been right now that you currently have on your agenda?
So I think CF has about 6 rules or rule proposals out the door or about to go out the door. That means they've been acted on or about to be acted on in the Commission. But overall, we're working on about 20 different rules, but who's counting? So as I said, we're extremely busy. We were happy to see our first rule adoptions go out the door, and a number, again, of proposals that have been approved and put out by the Commission. They're open for public comment. We're looking forward to receiving public comments. And then again, we're hoping to get a bunch more out before the end of the year, and then we're just going to continue to work and try to formulate these proposals, present them to the Commission, and get them out for public comment or for adoption in some cases.
And are there any that you've been keeping your eye on in particular, and that you're, I guess, especially eager to sort of see how the public comment process goes?
Yeah, so the audio's not that great, but I think you're asking me what are we in particular are we working on? So I guess I would say I could divide what we're working on to 3 buckets: disclosure, rules related to disclosure, rules related to trading, and rules related to corporate governance. And on the disclosure side, we're working on rules related to climate disclosure, human capital disclosure, cybersecurity, SPACs, and board diversity. For trading, buybacks, beneficial ownership disclosure under 13D and G, and insider trading, Rule 10b5-1. And in corporate governance, we're working on some Dodd-Frank rulemaking that didn't get across the finish line related to clawbacks. And we're also working on some proxy-related rules, universal proxy cards and proxy advisory firms. So like I said, we're busy, and I'm happy to go into any more details if any of those pique your interest.
Yeah, it's a remarkable amount of rulemaking by historic standards as well. And I'll try to speak slowly so that you can hear me. And for the audience, so Renee is only hearing my voice, so she's basically subjected to a speakerphone experience. Renee, can you speak a little bit about ESG? That we've talked a lot about ESG during the forum, and I would be curious to hear your thoughts on how you view ESG. And one, what type of disclosures we can expect to be implemented, and if you think this is about risk reduction or if there's other aspects about ESG that you view as relevant to shareholders and investors.
So sure. So with respect to ESG, I think sort of climate's the issue that people are most squarely focused on, and we're definitely focused on climate here at the SEC. So we're really thinking about investors' desire to understand better the climate-related risks that the companies that they're investing in. And we've heard from investors, large and small, representing trillions of invested dollars, that they want this information when they're deciding whether to buy or sell securities, and also when they're deciding how to vote their shares. And what we really have now is just array of voluntary disclosure frameworks. And so that's led to a situation where there's not as much clarity, consistency, or comparability as investors say that they need. And we've also heard from issuers who want more clarity regarding their disclosure obligations in this space. So we're working on a set of rules and recommendations that we're going to send up to the Commission to address these concerns and the investor demands. So with respect to climate, yes, we're engaged in rulemaking, but I also think it's important to point out the importance of climate-related disclosure based on our existing rules and guidance. So we had put out in 2010 guidance related to guidance on climate-related disclosures, and those still apply. And we want issuers to focus on them in their business descriptions, risk factors, and MD&A as appropriate. And just in September, we put out a Dear Issuer letter. And that letter just gives some examples of the types of comments that we might issue to companies as we review their filings. And of course, these are just sample comments. They're not an exhaustive list of the comments that we might issue, but we really want issuers to focus on current disclosure obligations sort of while they're awaiting, whatever new rules or guidance the SEC puts out.
And in addition to climate, in terms of the S and ESG, are there also social sort of aspects of disclosure as well in terms of workforce
so
diversity,
we are also
or in terms of
looking
other aspects?
at human capital disclosure, and that's also on our unified regulatory agenda. And again, it's very similar to climate. We've heard from investors that they want more information so that they can compare how companies are managing their human capital resources. So we're thinking about that. Again, there's a need for clarity and consistency in the disclosure. We're looking for possibly more tailored disclosure covering workforce turnover, skills and development training, compensation, benefits, demographics, including diversity, and also health and safety. So again, we're putting together a set of proposals for this more granular disclosure, and we're presenting that again to the Commission for their review. We're also considering a board diversity proposal. We already have under Reg SK item 407 requires disclosure about whether boards or nominating committees are considering diversity, but some institutional investors have asked us to consider rule changes that would require that companies present information about board diversity, gender, race, and ethnicity in a more structured format. So we're thinking about that and considering rules for the Commission.
Great. Thank you for that. Switching topics, you had mentioned SPACs, and within the capital markets this past couple of years, we've seen so many innovations in the kind of the IPO public offering process. We have SPACs, we have direct listings. I guess one question I had was what you're hearing in terms of from issuers or from investors in terms of when does the SPAC have a competitive advantage relative to an IPO? Or is that something that concerns the Commission, or is it not true?
Yeah, so I mean, SPACs are taking up a lot of our attention, especially on the disclosure review side. So the volume of SPACs, I think, has been up 4 times this past year compared to our most recently completed fiscal year. And the volume of de-SPAC transactions has been up 4 times. So with respect to SPACs, we're also considering rulemaking, and I've really asked the staff to consider disclosure requirements and whether the disclosure requirements that are in place right now are giving investors the information that they need when they're trying to decide whether to approve a SPAC merger or whether to redeem their shares. From our perspective, the mechanics of SPACs can get really complicated. Again, particularly at the de-SPAC stage, investors have to digest a lot of information about value, pipe investments, whether shares, how many shares might be redeemed, and the post-transaction capital structure. So we're really concerned about that, about disclosure regarding fees that the sponsors and the affiliates are receiving. And we're concerned about conflicts of interest. We're really concerned that the structure of SPACs means that in many cases, all the parties involved have strong incentives to complete a deal that's not necessarily going to be in the best interest of the stockholders who stay in after the de-SPAC transaction. And we're thinking about structural issues, sort of the big picture question that you've raised. How do SPACs fit into our mission to maintain fair and orderly and efficient markets? We're concerned about sort of the potential for an arbitrage play, parties pursuing SPACs to take advantage of possible differences in rules or statutes. So we're thinking about that. Should like transactions be treated alike? Do these opportunities for arbitrage present less efficient outcomes? And what can we do to sort of harmonize our rules across investment structures? So a lot of what we're thinking about is, okay, are people using SPACs to get around or to benefit from the PSLRA protections? Are people using SPACs to avoid, underwriter liability, tracing issues, and things like that? So we're really thinking really hard about the SPAC versus the IPO versus the direct listing, and whether we can introduce more harmony and more standardization across those transactional forms.
Yeah, picking up on a point you raised, so I think most people are probably aware of the PSLRA, but for those who aren't, there's a safe harbor under the Private Securities Litigation Reform Act, which is a safe harbor for forward-looking statements that is available to existing exchange-traded companies, which is a special purpose acquisition company would qualify. I know there's some legislation that's been introduced in Congress about basically adding to the list of companies that can't use the safe harbor SPACs. And I guess there's also an alternative, which would be to sort of extend the blank check company definition to sort of SPACs. And my recollection is your predecessor, John Coates, had mentioned that was a possibility. Do you think, is this sort of an area where Congress should sort of change the statute, or is it sort of, is it an area of rulemaking that?
Yeah, so I think I got the gist of what you're saying, how the PSLRA safe harbor appears, or at least many people believe it appears to apply to SPACs where it wouldn't necessarily apply in an IPO, and that's by nature of the statute. So my predecessor, acting director, I guess, John Coates, put out a public statement sort of raising questions about that. And he pointed out that from the perspective of the target company, the SPAC is actually an IPO. So it's not clear that the PSLRA safe harbor applies. So that's an interesting and a provocative statement. And it's something that we're looking at, that we're thinking hard about how to harmonize treatment across transaction structures.
And on the harmonization front as well,
exactly.
There's in terms of the Section 11 liability that applies in the IPO context, it's obviously, that's an area that's very different with the SPAC, and it's also different with respect to a direct listing potentially as well, given tracing concerns. To what extent can rulemaking address that? It's sort of the litigation risk difference between the three alternatives.
It's something that we're thinking about, and something that we're looking at. Other people have pointed out the concern about underwriter liability, about concerns about the quality or lack of quality of due diligence in these SPAC transactions. Many people attribute it, again, to the lack of underwriter liability. So it's an issue that we're thinking about, okay, are there ways that we can address this to sort of bring more uniformity across these transaction structures?
One issue also that's sort of resurfaced in recent years is the universal proxy. That was an issue that was, initially there's a proposed rule that was, I think it was in 2016, and then it kind of just lay dormant for the last several years. And in the spring, the SEC reopened for comment the universal proxy proposed rule. And so I guess the question is after all these years, do you think there will actually be a final rule promulgated on universal proxies?
Funny you should ask. So yes, a universal proxy, it's on our unified agenda. We actually have an open meeting scheduled for next week where we hope that the commission is going to take up our proposal. So way back in 2016, as you mentioned, the commission proposed a universal proxy rule, and that's a rule that just basically requires that all issuer and dissident nominees all be presented on a universal proxy card. And this would allow shareholders who vote by proxy to vote for any combination of director nominees, that is management nominees and dissident nominees that they select, just as they would be able to if they were voting in person at the annual meeting. And so the rules that were proposed established new procedural requirements that govern the use of universal proxy cards. So that was reopened earlier this year, and we solicited public comment. We got about 30 comment letters. Most of them were supportive of the rule. In fact, support for universal proxy seems to have grown since 2016. So we've considered all those comments, and we've already presented our recommendations to the commission. And again, we're expecting them to take those up and consider them next week.
Okay, so it sounds like there will be something to look forward to on that front. One other issue as well that caught my attention was the staff legal bulletin regarding 14A8. So that was fairly recently put out, and I guess I'd be curious to hear a little bit about some of the context that led the staff to reconsider basically in particular the business exclusion basis for shareholder proposals.
Yeah, so as you know, the shareholder proposal rule is an area where we get a lot of action every proxy season with respect to no action letters from shareholder proponents are putting forth proposals, and management often writes in seeking to exclude the proposal based on some of the exclusions that are built into 14A8. So about 2 weeks ago, the staff put out a new staff legal bulletin on 14A8, and that basically takes the place of the division's 3 prior bulletins on that subject. And I'll just mention a few key points. Rule 14A8I7, which is the ordinary business exclusion, is sort of where most of the action is with respect to no action letter. So I'll focus my comments here. So with respect to the significant policy exclusion under 14A8I7, in our staff legal bulletin, we said that we're no longer going to focus on the significance of a particular policy issued to a company. We found that approach had pulled the staff into factual considerations that don't advance the policy objectives behind the ordinary business exception. And we also found that approach was not yielding consistent and or predictable results. So the upshot of this is that staff is no longer going to focus on the nexus of a policy issue and the company, and instead we're going to be focusing on the broader social policy significance of the issue in the proposal. And so as part of this new approach, we're not going to be expecting companies to provide a board analysis, which would demonstrate that the policy is excludable under the ordinary business exception. We also addressed the question of micromanagement. And on that issue, proposals that could be excluded under micromanagement, we're going to follow the commission's guidance, which was provided in its 1998 release. So we recognize that proposals that seek detail or seek to promote timeframes or methods don't necessarily constitute micromanagement. We're going to be focusing instead on the level of granularity that's sought in the proposal and whether or not the proposal inappropriately limits the discretion of the board or management. So we're going to be looking at the level of detail included in a proposal to see if it accords with what investors need to assess issuers' impacts, progress towards goals, risks, or other strategic matters that are appropriate for shareholder input. And we had a no action letter that went out earlier this year for ConocoPhillips Company, and that provides, I think, a pretty good
So Renee, you cut out a bit there, but you were referring to the ConocoPhillips no action letter, which, for those in the audience, was basically an illustration that the SEC staff, the staff letter, the staff indicated reflected the new position, which is that you can have a shareholder proposal that can't be excluded, even if it has, the request was to have climate-related disclosures within a certain period of time, and that was deemed not to be an issue of micromanaging the company. So is that? I think, are you back? Are your audio back, Renee?
Can you guys hear me?
You cut out for a minute, so I was trying to summarize.
Oh,
that.
yeah, I can hear. Yes, yeah, I think I heard what you said about ConocoPhillips. That was a proposal where they had asked the company to set some goals with respect to greenhouse gas emissions, and we had said, the staff had said, this was before I got here, but the staff had said it wasn't excludable because it didn't micromanage to such an extent that it, violated, or that it amounted to ordinary business. So we're basically, again, trying to keep our guidance and our staff guidance in tune with what the commission has said, and we really think that we're trying to preserve management discretion, but not prevent shareholders from providing high-level direction on strategic corporate matters. So that's sort of a nutshell of what the SLB said. We covered some other issues, including the economic relevance exception, and then we also reprinted some of the guidance from the SLBs that we rescinded, so that all of that information would be in one place.
Great. Well, thank you so much for taking time today to talk to us about what you've been up to at the SEC. It sounds like it's keeping you busy, which again just makes me all the more grateful for your willingness to take time today and to work through the technological issues we had so that we could hear and see you. So thanks so much.
All right, well, it's great to be here, and thanks a lot for your time.